defense?
Leland McCray on behalf of Mr. Ross, who's standing in front of me.
All right, and Mr. Porter?
Yes, Your Honor.
And you're on this case as well, is that correct?
That's correct.
All right, and
Objection, Your Honor.
let me finish. Here's the thing. Let me finish. All right, and also, Mr. Porter, you're second chair?
Yes, Your Honor.
All right. So, Mr. Ross, it's the court's understanding that you wish to proceed pro se, is that correct?
It is correct.
All right, you're going to raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Do.
All right, you can lower your hand, state your name for the record.
James Ross,
All right, how old are you?
43,
And what is your highest level of education that you've completed?
second year in college.
All right, are you able to read, write, and understand English?
Yes.
Are you under the influence of any type of alcohol, drugs, or medication?
No.
Have you ever been treated for mental illness or any type of cognitive impairment?
No.
Do you understand why you're here today?
Do.
And why are you here today?
Being accused of aggravated robbery and intending to defend myself against these charges.
All right, do you understand that in felony cases, you have an absolute right to have an attorney?
I do.
And do you understand if you cannot afford an attorney will be appointed to you?
Understand that.
And you understand the attorneys that have been appointed to you are Leland McCray and Robert Porter as second chair. Do you understand?
I do understand that.
And do you understand that the appointed counsels are trained in the practice of felony criminal law and trial practice?
Hard for me to tell.
Now, here's the thing. I'm asking you questions, and your answers to my questions are going to be appropriate. We're not going to do this thing where we're saying disparaging things against each other. Do you understand?
Do.
So, you understand that your attorneys are trained in felony criminal law.
Do.
And you understand that they're trained in trial practice.
Do.
And do you understand in order to be appointed to represent you, they have to have been approved for appointment levels at the level of first-degree felonies?
I do understand.
Okay. And have you discussed with your attorneys your request to represent yourself? Have you discussed with both attorneys that you wish to represent yourself?
I have, but before we get to that point, I gave him ample opportunity for, produce any type of defense for these charges, and he's done nothing. He's not.
All right, just a moment. Okay, so I'm going to continue asking my questions and just, give me an answer. So it's my understanding, and we're back on the record, it's my understanding that you are asking to represent yourself. Is that correct?
That's correct.
Okay. Did you inform your attorneys that you wish to represent yourself? Okay. Now, do you understand that if you wish to represent yourself, there has to be a written voluntary waiver of the right to counsel? Did you understand?
I do.
All right. And that must be in writing and on the record. Do you understand?
I do.
Has anyone threatened you, coerced you, or promised you anything that would cause you to waive your right to have counsel?
No, but I have a question.
Yes.
So, would Mr. Porter be still sitting in my second chair with Mr. McCray being relieved?
Mr. McCray is not being relieved. Mr. McCray and Mr. Porter are co-counsels on this case.
I don't want him on my case, Your Honor. He's moved arbitrarily to my best interest.
Mm-hmm.
He's not filed a single pretrial motion, which relieves me of any type of pretrial maneuvering ability. I can't get a fair trial with anything he's done. He's refused to show me my discovery. He's secreting evidence from me. I don't even know the case, the state's case in chief about any of it at all. And it's been filed. And he's refusing to cooperate with me on these terms. Continues to embellish these stories as if I'm being aggressive to him in some way, but not producing anything in lines of the things that I've asked for.
So are you saying you haven't seen a police report?
I have not.
All right. I'm going to continue to go over this. And then if you're saying you haven't seen a police report, I'm sure they'll show you that police report right now.
Police report.
No. Here's what we're going to do. We're going to answer the questions that I'm asking of you. Do you understand? All right. So back to my question. You've informed the council that you wish to represent yourself. Is that correct?
That's correct.
Now, do you understand that per the indictment, these are, of course, felony charges? Do you understand?
I do.
Do you understand if the state is able to prove up their enhancements? Well, I'm sorry, let me rephrase. For each one of these cases that are in the indictment, the state has to prove each one of those counts beyond a reasonable doubt. Do you understand?
I do.
If the state is able to prove those counts beyond a reasonable doubt, and if they're able to approve the habitual offender enhancement paragraphs, your range of punishments for counts 1, counts 2, counts 3, counts 4 are 25 years to life in prison and up to a $10,000 fine. Do you understand?
I understand.
And do you understand that if they are able to prove the enhancements, there is no eligibility for probation from a jury? Do you understand?
I do.
Have you received and reviewed a copy of the indictment?
No, I have not.
All right. Mr. Ross, I'm going to give you a copy of your indictment.
And it says, according to Article 25.01, that the district clerk is supposed to.
Well, hand that back to me.
Thank you.
Yaya, if you will please give him a copy of his indictment.
Certified copy of the original.
And excuse me, and let me explain something to you. When you have an attorney that is representing you,
He's not.
the attorney will receive that, and the attorney will hand it to you, and that is through the district clerk. But we'll make sure you have that today. All right. Do you understand what you're being charged with in the indictment?
Do understand it.
All right.
But,
do you understand the elements the state must prove?
I do, and I object to the indictment.
Right. I'm sorry?
I object to the indictment.
All right. But do you understand do you understand all of the elements that the state has to prove?
I do.
Do you understand the full range of punishment with regards to each charge?
It's what you just explained to me.
My question to you is, do you understand the full range of punishment?
25 months.
So for the record, I'm taking that to mean that the defendant does understand. And do you understand you have a right to a jury trial? And if you choose not to have a jury trial, the state will have to agree to a waiver of a jury trial. Do you understand?
I do.
Do you understand that there will be 12 jurors that will be sitting to hear the evidence in this case? And those 12 jurors must come to a unanimous decision if they're able to. Did you understand?
I do.
Do you understand that during jury selection, there are available to you strikes and peremptory challenges?
I do. Or die.
All right. Yes. Do you understand if you're not a U.S. citizen that you will be deported, denied naturalization, and reentry? Do you understand?
I do.
All right. Then the court will allow the defendant to represent himself. And I'm sorry, after hearing all of the court's questions and answering them, do you still wish to waive your right to counsel?
As in, do I?
Do you still wish to proceed do you still wish to proceed in representing yourself?
I do.
All right. Then the court will allow you to proceed to represent yourself. There will be standby counsel. You'll need to sign the waiver. And once you sign the waiver, we will bring the jury in. We'll start with jury selection.
We need to sign.
Oh, you're gonna send?
I'm signing it. I'm just reading it. All right, take this off.
I've not been made aware of any motions being filed whatsoever. I'm completely in the dark about everything to do.
All right. Do you have a copy of the motion?
I can print it up right now, Judge.
And if you'll give him a copy of the motion.
Thank you, Judge.
And again, I'll get to that motion right now ahead of time. If I cannot understand what this fingerprints are necessary to identify.
And Judge, the motion was duly filed to the court as well as to defense counsel, Mr. McCrae, before the defendant decided to represent himself.
All right.
Mr. McCrae is not giving me any information about what's been filed in this case. And that's the reason that I asked before this proceeding began for him to be removed from our case. Also, I would like to bring up that Mr. McCray has threatened my one and only witness with arresting her if she's come to court and testify for me. That's my only eyewitness that has proof that this robbery did not take place. And he told her that if she comes to court, that she stands the risk of being arrested.
All right. Have you all printed out the motion?
I'm pulling it right now, Judge.
Thank you.
Judge, we'd also make an oral motion limine that the defense be barred from inquiring into any kind of criminal history of any of the witnesses. There are no convictions that I'm aware of.
One of the witnesses.
All right, so time out. One, we're going to let everyone speak one at a time. After people have concluded speaking, then everyone will have a chance to address whatever they wish to address. So you may continue.
Thank you, Judge. We would make an oral motion in limine that the defense be barred from mentioning or inquiring into any kind of criminal history of any of the witnesses. There are no convictions, so we would ask that there be no inquiry into any kind of criminal history or any kind of criminal acts alleged or not.
I would object to that, Your Honor, because two of the witnesses that are, first and foremost, they get to know my whole background. So these people are holding me, saying that I committed a crime. Their backgrounds need to be able to be ascertained as well. Furthermore, one of the witnesses that he's trying to protect is on probation currently for drug charges. Drug charges to prove that she is a drug addict, so which goes to the credibility of her statement. Furthermore, I also have a motion that I would like to.
No. We're staying with this motion, and then if there are other motions, the court will.
In regards to probation, it's deferred adjudication. She has not yet been found guilty of any offense.
All right. So with regards to the state's motion in limine, you'll need to approach before asking any question regarding any criminal history. And then at that time, I'll make a ruling. All right, next.
And Judge, those are all the state's pretrial motions.
I also have a motion that I would like to turn in.
Now we're on the fingerprint, and then we'll deal with your motion. So with regards to the motion that the defendant be fingerprinted, that will be granted.
Thank you, Judge.
All right, and what motions do you have?
This motion is actually a motion for continuance of 3 days, Your Honor, because I'm completely.
I have not seen the motion.
Okay, this is right here. May I make a copy of it, give it to the DA? Because I wrote this by hand.
You'll just need to show it to the prosecutor. No, you don't bring it to me.
The reason for this motion, Your Honor, is that I'm completely unprepared. I have not.
I have not seen the motion.
How do I let you see it? I wrote it here. This is it.
So this is what I'm going to explain to you. When you represent yourself, I am not allowed to tell you how to file motions. I'm not allowed to assist you, because then I become your standby counsel, and I'm neither party's standby counsel. I'm just here to hear any evidence that's presented to me, any motions that are presented to me, and make rulings. That is all.
I would like to attention and report that I am under strict abilities that I can't participate like the district attorney does. I don't have access to a computer or a copy machine or any.
Oh no, here's the thing. It's fine that motions are written, but they need to be given to the court in a specific way, and they need to be filed. Now, I am not here to tell you how to file motions. That is something that you need to know how to do, and you need to do.
You know how to do it, Your Honor. But if I was to file this motion, it would come past the time that this jury has been convened, and it would cause a problem with proceedings in court. So
that's not the way the law works. What you just said.
I don't know how else I'm supposed to file a motion. It's necessary at this moment when I don't have access to any of the basic things.
I just inform you that the court accepts written motions, but as far as my telling you how to do that, that is not what I'm here for. That is for you to decide how to do that in representing yourself.
So, Your Honor, I would like to make a verbal motion. The written copy of it is right here. May I?
And Judge, we would object under the Code of Criminal Procedure.
No, just a minute. It hasn't even been filed or brought before the court yet. And that is something that needs to be done. And so, Mr. Ross, this is what I'm going to tell you again, and I want you to hear me clearly. My role is not to help you with your case. I'm just here to listen to whatever is presented to me. That's it. If I seek to help you with your case, then I'm becoming your standby counsel, and then that means I'm not being objective. So I will not do that. And what I can tell both parties is I will only consider and rule on motions that are properly brought before the court.
I understand it. And I would ask for the court to have mercy and understanding. There are things that I'm limited to that I don't have access to at all. My hands are tied in this form of being able to.
This is what I'm going to tell you.
It's not fair.
No, this is what I'm going to tell you. And your attorneys will tell you this. My role in this case is not necessarily to have mercy and understanding. My role with regards to this jury trial is to listen to evidence, make legal rulings for motions that are presented before me, and make rulings on any objections that people may have. That is my role right here. I am not sitting. If you were found guilty, the jury would be in charge of your punishment. That's where mercy comes in. That is not with this court at this point in time. My only point is to review documents that are given to me.
My copies of the motion that I just did.
Right. If you'll make a copy, please. And a copy for the state.
Yeah. On record. Mr. McCray has been communicating with my only witness without my permission or knowledge. And
let me ask you this, and this is the only time I will ask this question. So, is it your belief that attorneys are not allowed to talk to potential witnesses? No, that's my question.
Not my understanding.
All right, so then I don't understand what you're asking of the court.
To understand an egregious crime that's taking place with obstructing justice from being served in the form of interfering with my client. Well, my witness is a veiled threat that she would be arrested if she testified in my case. I need her. She is key to my defense. And he's giving her a veiled threat. And if she testifies for me, she stands a chance of being arrested.
All right. And is this something that you're saying that the witness has informed you?
Yes.
All right. That's what's called hearsay. All right. Anything else?
On conversation, Your Honor.
Anything else?
Yes. I would ask that the court please move to have this man removed from my case.
That's your standby counsel.
My standby counsel is moving arbitrarily to my best interest.
That is your standby counsel. And at this point in time, your standby counsels, Mr. McCray and Mr. Porter, are just that. They are standby. They are not doing any more investigation as it relates to your case. They're just here.
Last night, Your Honor. He said a meeting with my woman this evening after court.
Yes.
If I can make a record, Your Honor, I've spoken to Tawana Monday any number of times. Tawanya Monday. I've spoken to her any number of times. I would like to think we have a solid enough relationship. I even got her to bring jail clothes to the jail for you. Okay, I've spoken to her numerous times, and yes, I'm meeting with her at 5:30 today on your behalf and to talk to her about her willingness to testify. Because yes, according to the state's allegations, it can make the argument that she was your getaway driver. So what I told her was, hey, you might want to consult a lawyer before you testify. I'm bringing her here today so that I will let her know if she needed one, she wouldn't even have to pay. This court would appoint her a lawyer to give her whatever advice and counsel that she needs. And if she got on the stand and pled the fifth, saying that she's not going to say anything because of any possible criminal liability on her part that does not reflect well on you, that's what I communicated to her.
I understand that, but before you even started communicating with her, she was full willing to be my witness.
All right, so stop. This is what I'm going to tell you. Number one, any witnesses that may or may not place themselves in a potential for criminal liability, attorneys are appointed to represent them so that attorneys can guide them on whether or not they should be testifying. And what I can tell you is, in cases, if somebody is charged, hypothetically, if somebody is charged with a criminal case and they want to call, I don't know, their co-defendant, then that co-defendant has a right to have an attorney represent them so that they can help them navigate on whether or not they want to testify and what the potential legal and criminal consequences of that will be. So here's the thing. I'm just here to hear motions. All of this side thing that you're doing, we're not here to hear that.
It's not a side thing, Your Honor. It's crucial to my defense.
Mhm.
Okay.
All right, State.
Judge, I'm in receipt of the defendant's motion for continuance. We would object because, one, it is not timely. It is being filed on the day of trial, where the code necessitates that all pretrial motions be filed within 7 days of trial. And further, Judge, I don't believe this is notarized, so it wouldn't be in compliance with the Code of Criminal Procedure for a motion for continuance. Because of that, we respectfully ask the court deny the motion for continuance.
I disagree with this on the grounds of have no way to get, I don't have access to a notary. I presented it to the court the best way I knew how by giving it to the district clerk to present it to the court in this time. The reason for the 3-day continuance that I don't believe would be such a burden on the court proceedings is because I've been kept completely in the dark about all the evidence to do with this case. I don't have any idea of the way or the evidence or the witnesses that the district attorney is planning on using in this case. So therefore, I cannot build a reliable defense against something that I don't know that he has or not. He could just pop up with this mysterious evidence, and I have no clue of it. It's not a fair trial if I don't know what he's got to go against me with so that I can build my defense against it.
All right, this case has been pending for jury trial since October 9th, 2025. It is now February 3rd, 2026. And so we are proceeding with jury trial. So we're proceeding with jury trial.
I would like to object because I have no clue of the evidence that the district attorney has against me. Mr. McCray has not made me aware of any of the pretrial motions that were filed. And furthermore, he did not produce a single pretrial motion in this case. And he would not communicate with me regarding anything to do with this case. It's just, it is not any way can be considered fair that this ground we stand on for this contest if I don't know the facts of the case.
All right, motion for continuance is denied and the defendant will be fingerprinted. Is there anything else before the jury comes out?
Nothing from the state, Judge.
All right, thank you.
Judge, I'm sorry. I would ask for the timing for the defendant to be fingerprinted. Our fingerprint examiner is here.
Let's do it right now.
Thank you, Judge.
I object to this, Your Honor. What is the reason for the district attorney's fingerprints? I have no clue of this. So I think in order for it to be fair, we have to be brought to speed about what it is that you need these fingerprints for when y'all got 10,000 copies of my fingerprints downstairs.
Okay, so this is what I will tell you. The state filed a motion. They're requesting your fingerprints. The court has granted the motion. So he's going to take your fingerprints. So please remove that objection.
I need my witnesses, Your Honor.
All right, Deputy Laura.
With evidence on the record, which I've been denied the opportunity to do.
All right, Deputy Laura, if you'll line the jurors up, please.
Not all, I mean,
I'm going to state to you, I am not your standby counsel. There are procedures that are followed in criminal law for a jury trial. You may want to speak with.
There's a subpoenas for her that she'll get served at 5:30 today.
no, she won't be there.
We're ready.
Stop talking to my witness.
Oh, the jury?
All right, everyone, please be seated. Ladies and gentlemen, you received an oath downstairs, but I'm going to give you an oath for this specific trial. So if you all could raise your right hand for me, please. Do you and each of you solemnly swear that in the case of the state of Texas versus Mr. Ross, you will a true verdict render according to the law and the evidence, so help you God? All right, you can lower your hand. So in this case, Mr. Ross will be representing himself. Mr. McCray and Mr. Porter are his standby counsel. All right, State, are you ready to proceed?
Yes, Judge, we are ready to proceed.
You may proceed.
Thank you, Judge. Judge, may I have a timer?
No.
True bill of indictment. In the name and by the authority of the state of Texas, the grand jury of Bexar County, state of Texas, duly organized, impaneled, and sworn as such at the September term AD 2025 of the 399th Judicial District Court of said county, in said court, at said term, do present in and to said court that in the county and state aforesaid and anterior to the presentment of this indictment. Count 1, aggravated robbery. On or about June 1st, 2025, James Ross, hereinafter referred to as defendant, while in the course of committing theft of property and with intent to obtain and maintain control of said property, did intentionally and knowingly threaten and place Janice Jones in fear of imminent bodily injury and death, and the defendant did use and exhibit a deadly weapon, to wit, a firearm. Count 2, aggravated assault with deadly weapon. On or about June 1st, 2025, James Ross, hereinafter referred to as defendant, did intentionally and knowingly threaten imminent bodily injury to Alyssa Ramirez, hereinafter referred to as complainant, by pointing a deadly weapon at and in the direction of the complainant, and the defendant did use and exhibit a deadly weapon, namely a firearm. Count 3, aggravated assault with deadly weapon. On or about June 1st, 2025, James Ross, hereinafter referred to as defendant, did intentionally and knowingly threaten imminent bodily injury to Daphne Smith, hereinafter referred to as complainant, by pointing a deadly weapon at and in the direction of the complainant, and the defendant did use and exhibit a deadly weapon, namely a firearm. Count 4, unlawful possession firearm by felon. On or about June 1st, 2025, James Ross, hereinafter referred to as defendant, did then and there, having been convicted of a felony offense of aggravated assault with a deadly weapon, to wit, a firearm, on April 30th, 2007, in cause number 0966641D, and the 396th District Court of Tarrant County, Texas, intentionally, knowingly, and recklessly possess a firearm after the 5th anniversary of the defendant's release from confinement following conviction of the felony, and the defendant's possession of the firearm occurred at 4427 De Zavala Road, San Antonio, Texas, which was a location other than the premises at which the defendant lived, against the peace and dignity of the state.
To those counts, how do you plead? Guilty, not guilty, or no contest? All right, State, you all may be seated. State, do you have any opening statements?
Yes, Judge, if I may proceed.
You may proceed.
Thank you, Judge. there's a man coming into my shop. I recognize this man. This man's been working with us for the last few days, but now he has a gun. He's demanding money from me, and he's putting it up to my throat, saying that I better pay him the money he's owed. The evidence will show that this is exactly what happened when the defendant walked into Janice Jones's shop after he had been working with her for 2 days and said that he was going to get paid the money he's owed. And we will prove to you with evidence, with documents, and with testimony that the defendant committed this crime against 3 people. And I'm convinced that when all the evidence is in front of you and when all is said and done, you will come back with the only verdict that justice demands, and that is the verdict of guilty. Thank you.
Defense, any opening statements? You may proceed. Yes, you may proceed.
Janice Jones is the owner of Alterations and a gift shop on Desabella Road. She's going out of business. A friend of hers approached me because her going out of business.
Judge, respectfully, I'm going to have to object. We're getting into facts that are not yet in evidence. You can say what evidence is going to show, but can't go into testimony.
All right, that objection will be overruled. You may proceed.
Thank you, Judge.
On the day in question, I receive a phone call, or I make a phone call and inquire as to how to collect on these owed. I was instructed to, or the defendant was instructed to proceed to the shop on Sunday to collect. They did. But the owner who instructed him to come didn't have the money that she told him to come to pick up. Then they left. Then he went to the car, and as he's leaving, he says to his girl, like, can you please go back into the shop and ask this woman how to go about